Welcome to Transnational Competition Law course, and dear learner, today we are going to discuss the entire adjudication of the competition dispute resolutions by the CAD or the National Competition Authorities of the Brazil. In the previous lecture, we have seen what is the constitutional mandate of the competition law, what is the place of the competition law in the entire scheme of the Constitution of the Brazil. We have also noted how under 1962 law, 1994 law, and 2011 competition law have created a kind of a system, a kind of an edifice which tries to see that there happens to be an overarching organization which reform the entire functioning of the CAD, and by a constant experimentation of the competition administration, dispute resolutions, and among the hierarchy of the dispute resolution authority as well as court, then how 2011 antitrust law happens to reform the entire functioning structure and the ideology of the CAD in giving a very expeditious disposal of the competition dispute. We have noted Article 5, we have noted Article 6, we have noted Article 12. We have also noticed uh, have seen the potentiality of Article 36 in promoting the entire sphere of the competition law in Brazil. Now, primarily, we come to the question that as to what is the role of the CAD being as an umbrella and vociferous organization of, of competition law and the policy, adjudication, enforcement, and embarrassment. In this respect, as we have noticed that the CAD which is to reform by 2011 antitrust law is having a general superintendent and two deputy superintendent under Article 12 of the new law. What we see that when these changes were brought about, the general superintendent happens to be appointed by the President of the Republic, and after the approval by the federal state for a term of 2 years with the possibility of reappointment, they used to work, and there is a security of the tenure of the general superintendent to work out of fear and favor in matters of competition. The removal of the officers of the CAD, meaning thereby the general superintendent and two deputy superintendent, happens to be a decision by the federal senate upon the request of the president of the republic, meaning thereby they enjoys not only the security of the tenure, but they also enjoy what you call the autonomy and independence, so that their actions and conduct are not to be made a case of public scrutiny and caricatures, and they have afforded some kind of a constitutional and legal protection in that regard. Besides, these superintendent, general superintendent, and two deputy superintendent also enjoy undisputable criminal conviction for international intentional crimes or disciplinary proceedings as determined by the law. Thus, we see that the antitrust law of 2011 in Brazil, the CAD has undergone to a sea change by prescribing the entire sets of the procedural law, because it has not only brought changes in the substantive law of the competition, it has brought changes in the administrative competition law, and it has also brought changes in the procedural competition law. And here, dear learner and viewer, we will try to see and gauge that as to how the antitrust law of 2011 vis-a-vis the role of the CAD as a nodal agency of the competition law enforcement in Brazil have brought some very radical reform in cases of the procedural competition law. In that respect, we see that the new law happens to see the CAT's own revenue, which are comprised of the entire system of the revenue generation and the internal revenue generations, has been augmented under the new law, so that the CAD happens to be a self-sufficient unit, and it can decide its own cases, and having a security of the tenure and autonomy and independence and free from any kind of a public criticism and conduct are not to be discussed in open public glare. and it was also made financially autonomous. And how that financial autonomy was conferred, we will see that there has been a series of changes which have been introduced. The one in matters to the procedural fee, in matters of remuneration of services, in matters of funding originating from the government, in matters of other entities and organizations, in matters of donations and grants, in matters of sale or rental or real estate and personal property, in matters of sale of publication, technical materials, data, informations, and some collected from application from the financial market, and any such income as has been envisaged and laid down under Article 28 of the Antitrust Law of 2011 of Brazil. That a perusal of Article 28 tries to impress upon the fact that this new law is going to make CAD a financially vibrant, financially sound, and financially independent organization by realizing the revenue and by having an internal generation of the revenue. Thus, we see that besides the fund from the government, the CAD has access to other financial resources which can enhance its financial independence from the executive. And it is one of the necessary thing and essential thing to have a kind of a decision which is very autonomous, independent, without fear, without favor, that any decision making authority, be that CAD or be that any kind of a judicial system, should be free from any kind of the financial embargo and financial crunch. So is the CAD, that it appears to be that it was kept out of any kind of a financial instability and the financial crunch, so that the general superintendent and two deputy superintendent can decide matter in a very decisive manner without any kind of a insecurity of their tenure and the service. Then, dear learner, we will be devoting to the question of that how the Brazilian judicial system has recognized the judicial precedent, although it has been said that the Anglo-American concept of binding judicial precedent is virtually non-existent in Brazil. Then it means the CAT's commissions are under no obligation to follow the previous decisions and previous judgments and previous verdict in future cases. Thereby, we have to see that what is the judicial apparatus of the competition law in Brazil, and from that standpoint of view, we can see the CAT's internal regulations, legal certainty, is only achieved if the CAT rules the same way at least 10 times, after which they codify, given a statement via the issuance of a binding statement. And in this respect, we have learned that in this respect, we have learned that the CAD, as of now, has issued 9 binding statements, all related to merger, review, and other subjects on the antitrust law. Then we see that whatever happens to be the mandate of Article 36 of the Brazilian antitrust law of 2011, it tried to set forth a basic framework for the anti-competitive conduct in Brazil. Article 36 have all potentiality to address all kinds of problems of anti-competitive market other than the merger. Article 45 of the Brazil antitrust law of 2011 follows, takes into account a large number of factors which have an influence on the decision making of the CAT, and then while setting any kind of a prosecutorial strategy for the competition law violations, what considerations are to be taken into account by the CAT, that has been laid down under Article 45, and it goes on to say that the level of seriousness of the infringement is the one criteria. The other criteria happens to be the good faith of the defendant. Then the third criteria happens to be the gain claimed or aimed by the defendant. And then the CAD has to see that the conduct has been a consumer, or the conduct has been consummated or not. It is only a real, or it is an artificial, or it has been consummated. That point, that conduct has to be seen in that perspective. Then the CAD try to see the level of actual as well as the potential harm to the competition on the Brazilian economy, the Brazilian consumer, and third parties in general. It tries to see that to what extent the anti-competitive activities under Article 45 happens to be detrimental to the economic effects caused by the conduct in the market. It also tries to lift and try to probe into the economic situations of the defendant, and it also take into account the all cases of recidivism. So we see that a large number of considerations are there which has been very meticulously brought out by Article 45. So we have to read the entire functioning of the CAD and the role of the CAD in between the prescriptions of Article 36 and the prescriptions of Article 45, and then try to see that what are those factors which are to be taken into consideration by the CAD in reaching to any kind of the amicable settlement of the competition dispute. And we see that each and every aspect has been well taken care of in their decision making process, or the judicial strategy of the competition dispute process. And then lastly, we see that the entire working of the CAD from that point of view, we see that fines must be, the CAD adopts more prosecutorial strategy of clamping the fine and realization of the fine, and that's why we see that during the last 5 years comparison of the judgments of the CAD in relation to the realization of the fines and the antitrust offenses, we find that the Brazilian Antitrust Authority has scored more hits and less misses in this process, and it is one of the most highly engaged kind of a competition dispute agencies with a mammoth workforce, and an ultimate delivery of the competition dispute happens to be highest among the BRICS are attributed to the Brazilian CAD. Thus, we see that CAD happens to be a kind of going into a very remarkable progress, and that continuous development is to be seen with a great respect and with great care to guide the other kind of the laws and policy in different BRICS jurisdictions, and in particular, and the other jurisdictions, competition jurisdiction in general. We now try to see that how the CAD happens to be as one of the important organization in heralding the anti-cartel judgment. And then we see that the CAD has imposed a large number of sanctions in regard to the terminate harmful anti-competitive effects, whereby the CAD may prohibit and require a specific conduct by the wrongdoer. In this sense, we see that the power of the CAD as an organization happens to be quasi judicial and as well as the quasi criminal in nature, because it tries to enforce some kind of a sanctions, and that issue we will be taking in a separate lecture, that how its power of sanction and enforcement, and how its power to declare the sham litigation, and how it tries to overreach the competition dispute vis-a-vis the intellectual property dispute into one, and how it applies to exclusion and the exemptions. That is also something very interesting in matters of CAD, and the CAD happens to be an organization of dispute settlement which have been very successful, not only in cases of antitrust violation, but its record to book the cases of the anti-cartel kind of a violation happens to be more than satisfactory. in the sense it tried to terminate all kind of the harmful anti-competitive effects and conduct, and then the quasi criminal nature of these organizations, and having a kind of a prosecutorial strategy, and having a regime of sanctions and enforcement, having a regime of the command and control. The CAD happens to a wide range of enforcement of the provision under its judicial apparatus, and that's why we see that the Brazil since 2003 down to this day, almost in 2 decades, that it has addressed a large number of issues of cartel and cartelization in a very successful manner. And if you look at the industry-wise record in that respect, we find that it has imposed exorbitant fine in the cement, in marine hauls, in LPG distribution, in medical and hospital services, air and maritime freight, and air cargo. And thus we see that the range and the coverage of the CAT's judicious role in imparting and delivering competition, dispute, and judgment and verdict in matters of anti-cartel or antitrust matters happens to be more than satisfactory, and therefore we have no option but to look the CAT's the overall functioning in shaping the competition law or the transnational competition law or the extraterritorial competition law, in giving a kind of an effect which can be immaculated and replicated by other jurisdictions of the world in general, and the BRICS countries in particular. With this, dear learner, I conclude, and I wish you a happy learning, that whatever we discussed about the entire reach and outcome of the CAD will go a long way in understanding the fair play and a kind of a portrayal of the competition law and policy in BRICS region. Thank you very much.